Hi, I'm Rob Deutschmann, personal injury and disability lawyer. While a personal injury matter is ongoing, the parties will have a discussion at some point about a settlement mediation. A settlement mediation is one popular method to try and resolve your personal injury matter sooner rather than later at a trial. One benefit of a mediation is that all parties are focused for the day on your matter. The parties have been preparing in advance for the mediation, and during the mediation, the parties are focused only on your file for that day. You and the representative for the insurance company are the decision makers. Whether you get damages or not, and the amount of those damages, are decided by you and the insurance representative. At a trial, the question of damages and how much is left out of your hands and in the hands of a judge or 6 people in a jury box. The parties participating in a mediation will include you and your lawyer, a representative from the insurance company for the defendant and the defense lawyer, and the mediator. The defendant does not attend. The insurance company is responsible for all decisions regarding the claim on behalf of the defendant. A global settlement meeting, which is similar to a settlement mediation, may also include representatives from your accident benefit insurer. Even a long-term disability insurer may be invited if you are receiving long-term disability benefits or there is a dispute because your disability benefits were denied or terminated. The mediation is intended to be an informal setting. It is fine to dress casually. A mediation can last on average 5 to 6 hours, and so you want to be comfortable. The parties to the mediation will work through lunch, and lunch is brought in for the participants. The mediator is generally an experienced personal injury lawyer. The mediator may have experience as both a defense lawyer acting for insurers and plaintiff lawyer acting for injured victims. This experience is invaluable in helping the parties to try and reach a settlement resolution on the day of the mediation. The mediator does not tell us who is at fault and what is the amount of the damages that should be paid. The mediator is there to assist the parties to try and come to a mutually agreeable settlement. Mediators work very hard to try and help the parties to reach a compromise and settle the claim. A mediation is held on a without prejudice basis. That means nothing said at the mediation can be used by any party if it fails and litigation continues. A mediator cannot be called at a future date to give evidence against either party. They maintain strict confidentiality and impartiality. Prior to the mediation day, all parties will have submitted a mediation brief outlining their case along with the key medical and liability documents. Each party will want to put their best case forward, and this provides you with an opportunity to see what the defense case is based on. As part of the preparation process, the plaintiff's lawyer will have arranged for various expert and treating physician medical reports, future care reports, and accountant reports to assess the value of your income loss and the cost of your future care needs. The defendant insurer is always assessing the value of the case. This assists the insurer in setting their reserves. Reserves are the amount that they anticipate in the future they may have to pay on your claim. Providing the insurer with more information in a timely manner allows the insurer time to properly assess the claim. It will also assist the insurer in their internal file reviews to determine how much they will pay for damages at the mediation. This is called the insurer's authority. The plan is to provide the insurer with enough information to show the risk to the insurer of taking the claim to trial, and therefore they will come to the mediation with sufficient authority to settle the claim at mediation. The plaintiff's lawyer plays a very important part to inform the defendant insurer about the claim and highlight the risk to the insurer that a jury will find in favor of the plaintiff and award sufficient damages to properly compensate the plaintiff. The ultimate goal of any mediation should be to get the insurer to offer all the money that they are authorized to pay at the mediation, or that the insurance representative will have to make a call to head office seeking additional higher authority to resolve the case at mediation. The mediation starts with all parties assembled in the same meeting room. The mediator will begin with opening remarks about the process and the mediator's role. The mediator's comments will be directed primarily to the plaintiff since all the other parties will have had mediation experience. Once the mediator is done, then the lawyer for the plaintiff will make a presentation. The presentation will vary, but generally the plaintiff lawyer, as will the other lawyers, will highlight the strengths of the plaintiff's case and note the weaknesses in the other party's case. The plaintiff's lawyer is directing comments to the representative for the insurance company, while the defense lawyer is directing comments to the plaintiff. Again, the remarks are directed to the decision makers. You will not be expected to answer any questions, like at a discovery. However, all parties are expected to listen to the other side's presentation in a silent and respectful manner, no matter how offensive the presentation may seem. The plaintiff may make a short presentation. Generally, these are comments about the injuries and how they have affected various aspects of the plaintiff's life. Once the presentations are completed, then the mediation moves to the negotiation phase, as the parties now work towards a final settlement. After the presentations, the parties then move into separate rooms. The negotiation portion of the mediation is about to begin. The mediator may want to have a discussion with the parties separately to discuss the strengths and weaknesses of each party's case. Once that is done, negotiations begin. The plaintiff will make the first offer to the defense. The mediator will receive the settlement proposal and convey that proposal to the defense. You are not permitted into the room when the proposal is presented. The defense will consider the proposal and then provide the mediator with settlement instructions for their counterproposal. The mediator will then come back into the room with the plaintiff and present the counterproposal from the defense. This settlement process will continue for several rounds, with the plaintiff reducing their demands each time and the defense increasing their proposal. Usually this process will occur over 4 or 5 rounds of back and forth proposals. During this settlement process, the mediator will generally provide some comments to the plaintiff and separately to the defendant, again outlining certain aspects of the case that the plaintiff and defendant may want to consider when putting the proposal together. The goal of the mediator is to help the parties reach settlement. Aside from comments on what they observe as the strengths and weaknesses in each party's case, the mediator will use any other information obtained during the process to try and reach agreement. However, the mediator will not disclose certain information if you wish the information to be confidential. Most mediations, when well prepared, result in a successful settlement. However, if the mediation does fail, then the litigation process will continue. You should also remember that while mediation is the best opportunity to try and settle your claim, settlement discussions can be held at any time, even after a trial has started. I'm Rob Deutschmann, personal injury and disability lawyer. Whether you're suffering from injury or disability, you don't have to face it alone. My personal injury team is dedicated to ensuring you receive full compensation for your injuries. We are committed to your future.